This is a production of O'Brien Communications.
Hello, friends. I'm Tim O'Brien. Chances are, if you ever had a serious problem with heartburn, you might have taken the popular drug called Zantac. The generic form of the drug is called ranitidine. In 2020, the FDA requested that all manufacturers of the drug withdraw all prescription and over-the-counter ranitidine drugs from the market. This was part of an ongoing investigation of contaminants in ranitidine. Fast forward to May of this year. That was when Pfizer, one of the manufacturers of Zantac, agreed to settle more than 10,000 lawsuits about cancer risks, all related to the now discontinued heartburn drug. Still, this company and these lawsuits do not represent the entirety of the problem or the legal woes for the manufacturers. That's what we'll be talking with our guest about today. Meanwhile, before we get started, if you're watching on YouTube or Rumble, make sure to hit that subscribe button. And if you're listening, wherever you listen, give us a good rating and review. Today, we're joined by attorney Brent Wisner. He's a managing partner and lead trial attorney at the law firm of Wisner Baum. He's been recognized as one of America's 50 most influential trial lawyers by Trial Lawyer magazine. We're talking to Brent today because he serves as co-lead trial counsel in the Zantac Products Liability Litigation in Delaware. Welcome to the podcast, Brent.
Thank you for having me, Tim. I appreciate being here.
I appreciate you taking your time. I know you have a lot of deadlines related to this litigation, and that's a very pressing issue, and there are new changes every day. So before we get into the actual litigation, I wanted to ask you a little bit about Zantac itself. The medication, ranitidine, is the generic form of it. There's not just one manufacturer. So if you could give us a little background on what Zantac is or was and what it was supposed to do.
Sure. So Zantac actually is something called an H2RA blocker. It was designed and invented in the 1980s, and it was a copycat molecule from a drug that we also know that's an antacid medication called Tagamet or cimetidine. What the small company out in England, Glaxo at the time, wanted to get into this really, really lucrative market. And so they took the chemical structure of cimetidine and they took off one aspect of the molecule, added on a nitroso part of the molecule, and created what we call ranitidine. Incidentally, it was that exact process of adding the nitroso element to the molecule itself that actually created the problem. And it was a problem that they identified in the early 1980s, but they didn't tell anybody about it. And so the way the drug works basically is in your stomach, there's these different receptors. And when a histamine goes into that receptor, it effectively triggers the production of acid in the stomach. It's similar to the production of mucus in the nose. It's a different histamine in your sinuses, but it's one in your stomach. This effectively physically blocks that histamine, prevents it from being activated, which then in turn reduces the production of stomach acid. Ranitidine, because of the way it's physically shaped, similar to the cimetidine molecule, was really effective at it. And actually at the time that it came out, it was considered more effective than cimetidine at stopping the stomach's production of acid. So that's basically how it works.
That's a pretty good explanation based on everything that I read. I'm sure you're used to summarizing something that scientific in such a simple way. I want to go back to that history then. You talked about the 1980s. You mentioned Zantac basically was launched in 1983, and it became, according to the research I found, it became the world's best-selling medicine in its category in 1988. And it was one of the first drugs to top $1 billion in annual sales, and that's back in the 1980s. And one of the things I wanted to ask you about, because oftentimes we associate a single drug with a single brand name or a single company. So we know that, as I mentioned in the intro, Pfizer was one of the manufacturers of Zantac, but it did not have a monopoly on the manufacture of Zantac. There were four: Pfizer, GlaxoSmithKline, GSK, Sanofi, and Boehringer Ingelheim, if I'm pronouncing that correctly. So why is it that way, that four different companies are manufacturing the same drug? Is it a licensing deal?
Well, basically, when it first came on the market, it was this prescription medication. And at that time, in 1983, it was brought to market by Glaxo, which would later on go acquire some companies to become the company we call GlaxoSmithKline today. But in the 1990s, as the patent for the prescription was coming to an end, Glaxo wanted to bring the product to market over the counter. And so they actually teamed up with a company called Warner Lambert, which would later become Pfizer, to come up with and develop the over-the-counter version of Zantac. And so in 1995, at the end of 1995, they got it approved. And so what had been previously a prescription medication also became available over the counter. So you didn't need a prescription. You could buy it at a CVS without a doctor's note. And it came to market in a joint venture between GSK and Pfizer. After a couple of years, as we know with most pharmaceutical companies, that relationship broke down. At that point, Pfizer took control over the over-the-counter medication, and GSK maintained control over the prescription medication, and it continued on for a few years. Then in 2006, Pfizer sold their Zantac label or brand to Boehringer Ingelheim. They had it for 10 years, and then Boehringer Ingelheim in 2017 sold it to Sanofi. And so when we talk about the different manufacturers, GSK sold and manufactured the prescription brand name for Zantac, and then Pfizer, GSK at the beginning, and then Boehringer Ingelheim and Sanofi were responsible for the over-the-counter versions of the medication. They're the same molecule, just one's available prescription and one's available over-the-counter.
That's a good sort of family tree for the drug, and somewhere in the middle of there, then, and I know this is the subject of litigation as far as who knew what when, and when did they first start noticing problems with the drug. And before getting there, I mentioned there was a contaminant in my intro, that the FDA was concerned about a contaminant that's in ranitidine, and the short acronym for that is NDMA. So could you tell us a little bit about why not so much why the FDA did it, but the FDA centered on NDMA. What is NDMA, and why was it an issue, and was it in ranitidine?
Sure. So NDMA, or N-nitrosodimethylamine for the nerds out there, is a type of nitrosamine, which is a family of chemicals that are very well studied. They've been known about since the early 1900s. NDMA specifically is just a horrible chemical. It has no good value in our world. It was discovered during World War II in the early 30s, before World War II, in the production of rocket fuel. And it was used as a way to catalyze that production process. But it was quickly learned that NDMA causes cancer. It literally gets into the body, it metabolizes into this horrible substance that just causes all sorts of genetic damage. And it's been known pretty clearly about this for well over 50 years. In fact, in the 1970s, the International Agency for Research on Cancer basically said, for all practical purposes, this is a human carcinogen. And they were able to do that because in every single animal and every single species it's ever been exposed to, it has caused tumors across the board. So in the 1980s, when this product came to market, the world was very aware of NDMA, and it has no business being in any medication. In 2019, however, that's the first time the FDA became aware of this problem. Now, the truth of the story, it actually starts in the 1980s, and I can tell you that story in a minute, but NDMA is a nasty substance. And the FDA, as soon as they learned that there was NDMA in Zantac, and that specifically that the molecule will break down just sitting there on the shelf and turn into NDMA over time, once the FDA understood that, they pulled it off the market in April of 2020. And basically, the product has never come back on the market. No one can really buy ranitidine anymore in the United States, and for good reason.
How does something like that end up in a product to begin with?
You know, in the 1970s, when they first were sort of getting really concerned about nitrosamines, they discovered at a chemistry molecular level, something called a tertiary amine. It's a type of molecule structure that can be found in a molecule. And they discovered that these molecule structures had the propensity to shear off, form with a nitrogen molecule, and form a nitrosamine, or NDMA. And in fact, this issue was such a concern that the FDA raised it with GSK in 1981. They said, we have concerns about this molecule because of the way it's formed. turning into nitrosamines. And the FDA said, okay, we want you to do experiments on it and produce all the information to us, quote, without editorialization. The next few months, GSK went out and started experimenting, and they conducted a standard test. It's called the NAP test. It's developed by the International Agency for Research on Cancer, specifically to identify things that can nitrosate, which is what we're talking about. They conducted the test, and they found, holy crap, ranitidine quickly forms into large amounts of NDMA, I mean, staggeringly high levels. But GSK got that study, and even though the FDA said, do the experiments and share it with us, they buried it. They hid the data. And in fact, they ended up publishing a different study suggesting that there was no other nitrosamine formed to mislead a bunch of independent investigators in the FDA about what was happening. That study that they had done didn't get publicly made known until we filed lawsuits, until they were forced to disclose it in discovery. And only at that point at the end of 2019, did GSK finally turn the study over to the FDA, just a few months before they pulled it off the market.
So this is almost simultaneous with the actual launch of the drug itself.
Well, it's actually during the development process. I mean, this is how drugs are made, right? The FDA raises concerns. Companies are supposed to allay those concerns with scientific investigations and studies. And that process was working even in 1981 and 1982. The problem is after they identified the problem, GSK buried it. I mean, it's a clear story of corporate malfeasance, one that, God willing, we get to a jury on this sometime soon, I think is going to really piss off a lot of people, because it's really an unacceptable abuse of the trust that drug companies have in that process.
Have you seen that study?
100%. I've seen the study. I've seen emails and memorandums within the company talking about how they don't want to share that information with researchers who are asking questions. I mean, we have the whole story laid out in spades. And then, of course, over the next 40 years, every time ranitidine was associated with NDMA, which it kept having problems with. They kept seeing, for example, that ranitidine would form into NDMA during water treatment of the sewage. When people were urinating ranitidine into the sewer system, it was causing NDMA contamination of the water source. They kept seeing study after study emerge, and every single time GSK and the rest of the defendants ignored it. They kept seeing that the product would convert into a yellow, oily substance, NDMA, and they kept not studying it. And it wasn't until a separate laboratory out in Connecticut called Valisure, which is an interesting story in of itself, went ahead and just did something that apparently no one had ever done. They tested the pills for NDMA, and then what they found was shocking. I mean, what they found led to the product being pulled off the market, within a few months.
When did the first known people who took that drug come down with cancer?
Well, we know cancer can have a short or long runway. I mean, it's an unfortunate reality that cancer is a confluence of people's sort of genetic susceptibility plus the exposures they have in the world. I mean, you all heard the example of someone who smoked their whole life and never developed lung cancer, or people who develop lung cancer and never touched a cigarette. It's, there's a combination of things. But what we know is that with the levels of NDMA that are found in these pills, that people could start getting cancer within 1 to 2 years of taking it. And, so starting in 1983, if people were taking these medications at a high elevated level, particularly people who had stomach issues that may, for example, be more susceptible to the development of cancer, there was likely cancer being started in, the 80s. And, the number of people who have developed cancer over the last 40 years, who died, whose stories will never be told, whose the casualties of the corporate malfeasance will never know, is kind of untold, which, is what leads us to why we're in litigation now with over, almost 100,000 people around the United States suing these companies for having developed different types of cancer.
What was the catalyst of the event to start the first litigation? So somebody had to be the first to sue. And before that, somebody had to be the first to recognize the connection that they think, the alleged connection between Zantac and their health problems. And then they had to decide to sue.
Yeah.
When did all that start?
Well, in early 2019, one of the founders of a company in Connecticut called Valisure, his infant daughter was actually prescribed ranitidine. Now Valisure is a company that has done different things over the years, but they're effectively a laboratory. And what they do is they test drugs to see if they have bad stuff in them. One of the things they test for is NDMA. So this founder, before he gave the drug to his child, asked Valisher, hey, will you just test this to make sure that it's safe, that it doesn't have any of these contaminants that we're seeing in other medications? They tested ranitidine and they found a lot of NDMA. It freaked them out. So Valisher then proceeded to do a series of experiments. They redid the NAP study that we mentioned earlier that IARC did. They did all these experiments, and they just kept seeing that this molecule was fundamentally unstable, that it had a propensity to degrade and form into NDMA. And so they did what the drug companies didn't do. They took it to the FDA. They filed a citizen's petition. Well, they actually contacted the FDA quietly. Then they filed a citizen's petition. And as soon as it became publicly known, lawyers like myself and other plaintiffs' lawyers around the country got wind of that information and started being contacted by plaintiffs who had cancer and who had taken ranitidine for dozens and maybe decades and were very concerned that it had caused their cancer. And so we started signing people up and we filed lawsuits, and now we're 4 years later.
So it's really only been in the past 4 years when all of this started to happen. And there was this long dark period from, let's say, going back from roughly 2018, going back to 1981. So there was that period of time. And even though there were people who knew things back then or suspected things, if not knew them, they suspected problems, they suspected connections. There was never a whistleblower. There was never anybody that came forward and talked to the government. There was never a congressional investigation, nothing like that. What about the FDA? I mean, they requested that information. They never did a follow-up on that?
Well, no, the FDA ultimately, when they found out about it, because of Valisher, they immediately began an investigation. And obviously, within a few months, they took action and removed the product completely from the market because of this issue with NDMA. But the question you're asking is an important one. It's one that frightens me, and that is, how could these companies for decades, sell this product and never test it for NDMA, never take any action to tell anybody about these issues? I mean, we have the documents showing scientists within the company saying, hey, we're concerned about the chemistry of this molecule. We're concerned about all these unidentified contaminants that are forming in our stability studies. We are concerned about all these things. And the people who knew said, yeah, don't look, don't turn over those stones. And, the FDA, they don't test anything. The FDA doesn't actually do much of the bench laboratory work. They rely on the drug companies, to be honest. But when they lie, like they did here, when they commit rampant fraud, candidly, like they did here, the people who pay the price are the people taking the medications. And unfortunately, they don't get held to account until people file lawsuits and force these companies into what will be massive multi-billion dollar settlements to, help compensate some of the people who've been hurt by these drugs.
Well, that's pretty much the status of where we are now. And I wanted to put something on the screen because, as I said earlier, this case, or this set of cases, this whole litigation, it seems like every time I looked at the story before talking to you today, there was always a new article, and it seems like Reuters is on top of this story more than most. So Reuters put out a story on July 1st. We're recording this on July 3rd. And this was drug makers appeal to end Zantac cancer lawsuits rebuffed by judge. And I guess that's a good place to start right now. And that is, what is the current status of the litigation? And I know there's 70,000 cases, so you really can't talk about that. But just going by the most recent events, what does this mean when this appeal happened? And when I look at it right now, the appeal was by GSK. GSK made the appeal, and they basically said they want to have a ruling where they can appeal all these cases. And the judge, Medinilla of Delaware, Medinilla, I think is the pronunciation, of Delaware Supreme Court, made a ruling that basically means drug makers, and this includes GSK, Pfizer, Sanofi, and the others, they will have to ask the Delaware Supreme Court directly for permission to appeal. So they're not going to treat it as just a blanket appeal or a blanket request. So could you tell us exactly what that means? What are the ramifications of that ruling?
Sure. I think before I get to that specific point, a little bit of the backstory is important. Really, the litigation has taken, it's a story of two different worlds, right? We have the federal litigation and we have the state court litigation. The federal litigation, which was centered in a Palm Beach, Florida federal court, is dead for now. The court there has basically dismissed every case, has bought every single argument by the defendants, and has decided that there is no science supporting this case and has thrown them all out. Conversely, multiple judges now in state court in California, Illinois, and now most recently in Delaware don't agree. They've looked at our experts and said, there's a lot of science here. This gets to go to a jury. You don't get to decide, the science as a judge. And so we have really two completely different litigations happening. The federal litigation is up on appeal before the 11th Circuit. We'll see how that goes. But the state court litigation is alive and well, and cases are proceeding to trial. Now, the most recent one and the biggest state court litigation is actually in Delaware, and it's before Judge Medinilla, by the way, just how you pronounce it. And Judge Medinilla is a very smart and very hardworking jurist, really impressed by the work she's done. But she had a very lengthy argument, 3 days worth of hearings. She had thousands of pages of briefing, even many more thousands of exhibits. And she heard everyone out, and she ultimately decided that this issue should go to a jury, that it's not for a judge to decide science, it's up for scientists to decide science. Well, GSK and the other defendants, they don't like that. And they don't like being in Delaware, which they perceive to be a corporate-friendly venue. And they think it's outrageous that any court could ever haul them into court and make them potentially be accountable for their misconduct. So they have now basically snubbed Judge Medinilla and said, we want special treatment, and we'd like to go and get an appeal right now, even though we're not allowed to get an appeal right now. We want to be able to appeal this immediately, which is called an interlocutory appeal. They filed a request to Judge Medinilla. She resoundingly said no. I think her order was pretty clear, and she didn't pull any punches on the silliness with which they were seeking. It reminds me very much of just sort of vexatious litigation by the defendants. And now actually before they even got a ruling from her, they just went ahead and appealed it to the Delaware Supreme Court. And they've hired their cronies, the U.S. Chamber of Commerce, the pharmaceutical industry, to file amicus briefs saying if the Delaware Supreme Court doesn't do something, Delaware is going to no longer become a corporate friendly. All these policy and political arguments, which candidly have no business being in a legal question, in a legal appeal, but that's beside the point. GSK is desperate. Their backs are against the wall. We are breathing down their throat. We are going to go to trial, and we are going to pop them very largely with the verdict. And so they are lashing out. They are acting as desperate as I've ever seen a defendant act. And this is the latest gambit. And as of 2 days ago, that gambit is not working. So we'll see, obviously, what the Delaware Supreme Court does. They rule very quickly. I don't think in the history of the court they've never done this. Defendants have tried before. It's always been rejected. But I will say, we are in a brand new age where the Supreme Courts are doing things we've never seen before. So, but I don't think the Delaware Supreme Court will take it. I think this is going to move on to trial like it should.
Well, Pfizer settled 10,000 cases, and anytime you hear about a settlement, you almost always have to assume that there's no admission of guilt whenever they do that. That's the big trade-off. They'll trade off, they'll pay the settlements, whatever they are. And I'm not just talking about Pfizer and just in general legal terms. And they usually ask for, you're not going to get me to admit that we actually were culpable in this situation. And that's where a lot of settlements come from. And I know in your line of work, if you really feel you have a case and you can go to a jury, that is not only is that a huge outcome for your client, but it's also a huge outcome because a jury determines guilt or, culpability, responsibility. What do you think about that in this case? I mean, it seems like there's a tremendous amount of incentive for the pharmaceutical companies at some point to settle. And I know you don't want to give away your legal strategies here, but what do you think about that? Do you think that a lot of these cases are going to go to a jury, or do you think most of them will settle?
Well, I think what we know now, and I can't comment too much about settlement because I'm obviously involved in negotiations and they're very confidential. And by the way, one of the reasons why corporations never admit guilt in a settlement is because if they admit guilt in one settlement, the next plaintiff can come over and say, "Well, you already admitted you're guilty," so it eviscerates their ability to defend themselves in the future. So that it's a legal technicality essentially why they never do that. When you're paying lots of money, obviously that's indicative of recognizing potential guilt. But I'll say this: um, these defendants. So Pfizer has basically settled their cases. There's a few people they haven't settled with. They've basically resolved their exposure as a company. Sanofi actually has also settled outside of Delaware. They haven't settled their Delaware docket, but we'll see if we can get something done soon. The last big two defendants, GSK and BI, while they have settled individual cases that are on the eve of trial, they settled those cases. They haven't settled any big sort of dockets. And what we see here from sort of a market perspective, from a company existential existence perspective, is a huge difference, right? Pfizer, because they've cabined their liability, because they've been able to figure out a way to deal with this litigation in a way that the company can deal with financially, their stock is doing great. GSK is down, like almost $10 billion, or maybe less. I don't check it every day, but they're down many billions of dollars in capital value because of what's happening in Delaware, and because of their refusal to just come to the table and get a settlement done. They're playing this game of delay, of pushing things out, of forcing the case from never getting a person to have their day in court. And the reason why they're doing it is both strategic and malicious. It's strategic because the longer they wait, the more maybe willing plaintiffs are to settle. But it's malicious because people are dying. I mean, thousands and thousands of people have cancer, and people who have cancer don't always survive. And as these people die, their families don't want to pursue the claims or don't want to deal with the headache. They just want to mourn. And they're banking on people dying, people that, whose cancer they caused, to die so that their exposure goes away. It's a pretty callous and disgusting approach. And candidly, I think it's causing me in my strategy to say, fine, if you are going to sit there and waddle, the value of what your exposure is going up, because I'm happy to litigate these cases for the rest of my life. I'm happy to go get multi-billion-dollar verdicts. Look at Monsanto and Bayer today. When I started the Roundup litigation, they could have settled the case for $1 billion. We are 10 years out now, and they're over $16 billion in settlements, and there's no end in sight. They're on the verge of bankruptcy as a corporation. They had an opportunity to come to the table with me at day one and get rid of it, and they didn't. And
What litigation was that? When you mentioned Monsanto and Bayer, what litigation is that?
Sure, that was the Roundup lymphoma litigation. I actually tried the first case and the third case and got over $2.4 billion in verdicts against Monsanto that led to a $30 billion collapse in the Bayer value, a collapse that hasn't really fully recovered ever since, and it's led to hundreds and hundreds of thousands of people filing lawsuits, and the company is now facing bankruptcy. I mean, the litigation has truly posed a threat to the corporation. GSK right now is teetering on that line, right? With their refusal to come to this table and get this done and get our clients paid so they can move on with their lives and put this litigation behind them, people are starting to get interested in this case again. We're doing podcasts. People are hearing about it. And as more and more people come out, the exposure at GSK will reach a point where it becomes an existential threat to the company.
You said something, and I didn't want to let it go because I'm just going to probably say, if it's not already understood, that what you're talking about, this is all your opinion, unless you have facts to back it up. And so when you made that statement about GSK or these other companies dragging it out because financially, if the people who would sue are gone, have passed away, then that reduces the amount of exposure for them. That's what you said. Do you have any proof to back that up, or is that your opinion?
Well, the proof that I have is that they adamantly refuse at every step to proceed to trial. Every trial date they try to move, everything they try to push, and then they are insisting when people have passed away and we've tried to pursue claims, they've challenged the ability to pursue claims because the person is dead, or challenged their ability to seek compensation because they're dead. I mean, I can give you 1,000 many instances of actions by these defendants in an effort to prevent these cases from moving forward. So, I mean, walks like a duck, talks like a duck. Sometime at some point, you have to admit it's a duck. Now, maybe they have some innocent reason for dragging their feet and watching these people die. I don't know it.
I understand that. Now, I have a legal strategy question for you, and
Sure.
this is something that not just applies to this case or these cases, but in general, because you're a trial lawyer. But when you're dealing with something like this, or even a hazardous chemical that's in Roundup, there's that issue of cause and effect. How do you prove cause and effect? Because, and especially in pharmaceuticals, because a person can die of cancer, and they could have comorbidities, they could have other health conditions, they could have certain lifestyles, they could have had a job where they were exposed to certain hazardous chemicals, or it just could be hereditary. There are so many different causes of a disease like cancer. And you go into a court case, and I know you look at a lot of patterns and you see, well, there's a pattern that this person used this and this happened there. But I can't imagine that's good enough for a judge, a courtroom, or a jury all the time. So, how do you do that? How do you make the connections between the cause potentially of a particular drug or a chemical and an outcome, like when someone has cancer?
I think it comes to the law and what we understand of the science of cancer, right? When we talk about cause and effect, everyone's instinct is to say that there's one cause to an effect. But in the world of cancer, that's not how cancer works. No one thing causes a person's cancer, right? A good way of thinking about it is like a game of Russian roulette, right? And you have a chamber and there's a bullet in there and you pull the trigger. And do you bite the bullet or not? Most of the time, you don't, right? Most of the time, it's a click and it's not a boom, right? And that's how cancer is. Most people don't get cancer, right? Even if they're exposed to stuff. Now, what a carcinogen is something that affects the likelihood that you get the bullet. Not that you will get the bullet, but the likelihood of it. So, for example, if you pull the trigger twice, the second trigger would be a carcinogen, right? Because it's increasing the odds that you get the bullet. Or if you increase the bullets in the gun, or if you decrease the chambers, or you can think of a lot of different ways that you could affect the probability of getting the bullet. And so that's what we talk about with something that causes it, right? It's something that increases the probability that you get unlucky, right? Now, in the legal world, you don't have to prove that that one thing was the reason you got cancer, right? Because that actually is scientifically impossible. What you have to prove is that it's one thing that contributed to your development of cancer. And if you can show that, and you can show that that contribution was the conduct of fraud or negligence or malfeasance like we can here, then our law basically says you're still accountable, right? So the cause and effect intuition that people bring to the table, you just have to educate them. You have to explain to them that in the legal world, that binary cause and effect doesn't work, because if that was the case, then you could never prove causation almost of anything, right? There's always something else that was involved, and you could, whether it be a car accident or a pharmaceutical case. The law has created a standard that can be met and is importantly balancing proof with holding corporations accountable. And so if you have the negligence and you can show that that negligence was a cause, not the cause, but a cause of the injury, that's enough. And we've done it successfully in trial. And obviously it requires a smart jury. It requires good experts. It requires explaining the science. But I think when you do that and you lay it all out for a jury to understand, they get it. And, more often than not, I think they agree with you. And then they figure out, what does that mean and how do we compensate this person for that?
So, if I have this right, then you're basically saying you have to have something that could cause cancer or a problem. That's number one. You have to have a certain amount of risk associated with that. Were they exposed enough to get cancer? And then the third thing, and this probably in the courtroom is the big thing, is you have to prove negligence. You have to prove, did the company know there was a risk? It doesn't mean that they had to know it was an actual cause, but was there a risk, and what did they do about it? And
Precisely. And I also would point out one other thing we do, it's really important, is we take that person, right? We take that person's medical history. We take all their exposures, their age, their genetics, and we systematically assess it with the jury, right? All the things that could be potential causes, and we rule in and rule out the ones that make sense. And sometimes you're left with three causes, right? It's the medication, but it's also they had a genetic mutation, and also that they had a remote smoking history. That these three things together probably caused it, but each one of those things can be held accountable for if it was based on negligence. And so that process of what we call a differential, or differential etiology is the technical term, is an important part of bridging the science to the individual to show causation.
Does what you just described affect the damages you claim? So if you can consolidate sort of the causation at the company, that's higher damages, or if you could spread the potential causes out to 5 different factors, heredity being one of them, does that lessen then the amount of damages you might claim?
No, because the law recognizes that if you did that, it would basically inoculate people for bad conduct. I mean, the great example is two people start a fire in different spots in the woods. The fire crawls and then burns down a house. Well, who caused it, right? Well, they're going to say, well, the other person caused it, right? Because their fire would have destroyed the house. And the other person says, well, that person caused it. Their fire would have destroyed it. I mean, this is a classic legal conundrum. And the courts have, for a long time, said, no. You're both liable. You're joint and severally liable. Now, if you want to go sue each other and figure out who should get more of it, have at it. But for the purposes of the person who was injured, for the person whose house was lost, one or both pay, but somebody pays. And that's how the law is designed.
I got it. Now, the cancer risks, I looked up the types of cancers that people were involved in this litigation say that they have. Bladder cancer, esophageal cancer, gastric and stomach cancer. Those kind of make sense because that's basically what they were doing. They were taking a drug for heartburn, and these are the areas of the body. Liver cancer, pancreatic cancer, prostate cancer, breast cancer, lung cancer, and colon cancer. Those are all some of the more common cancers and serious cancers. That, as cancer goes, a serious disease, some of these are the most serious types, the ones that are hardest to treat and can be the most fatal for people to get those diagnoses. So going forward now, where do we stand now with these cases? What does it look like to you from the federal standpoint and the states?
Sure. So from the federal perspective, it's on appeal. The litigation is effectively at a standstill. There is one litigation that's ongoing currently in Philadelphia federal court that involves a whistleblower claim against GSK for fraudulent claims against the government. That's a pretty big case that just got started. It's really kind of getting going right now. But that's about it for the federal world. In state court, we have a lot of work. There's trials actively ongoing and being set in Illinois. The most recent trial is going to be in September this year. That's in California State Court. It's actually in Alameda County. It's actually in the same courtroom that I got a $2 billion verdict in Roundup. So that should be fun. And I'll be trying that with Jennifer Moore in September. And then in Delaware, we are now at the process of setting bellwether cases. So we're going to work up a couple hundred cases for trial. And then we're going to proceed to try them probably in group trials, multi-plaintiff trials for different cancers, and have that done in Delaware. So really in state court, it's trial. It's trial. We need to get to some verdicts. And then after the verdicts, we will, of course, go through the appellate process. I will say it's a dangerous game because if we go to trial and we are successful and we obtain very large verdicts, it will pose a very big problem for these defendants. I think there's kind of a sweet spot right now. And I think we've seen that with Pfizer and Sanofi, that this is the time to settle. And if we can avoid trial and get our clients, money and a way to get this whole situation put behind them and do it in a way that doesn't prevent the corporations from having to declare bankruptcy, I think that's probably the best of all worlds. But right now we are in litigation. GSK is acting out. It's lashing out in every way it can to avoid trial and to, dig Judge Medina in Delaware, and in federal court it's on appeal. So the litigation marches on, and we got some good lawyers and good experts who are at the front lines doing this fight.
If you have some victories in those trials, do you expect to get more clients?
We're always, if someone has a problem, we always have them definitely taking clients all the time. If someone, realizes they have cancer and that they took Zantac for a while, I mean, by all means, give us a call, or call any of the firms that are taking these cases. We are still taking cases. I think a lot of the cases that are going to be found have already been found because there's been so much publicity around this. But cancer has a long runway. Someone can get exposed to a carcinogen 5 years ago and develop cancer 20 years from now. And that's still a cause. I mean, that's well documented in the literature. So, the end of the cases is not here. Someone will develop cancer tomorrow who took Zantac, and that person has a case, and they should seek a lawyer immediately to make sure that their, rights are protected.
One thing we didn't talk about, and I know this could be a whole separate episode, but what is the potential for criminal? Now, you talk about people back in 1981 who may have known this, and some of those people, I'm sure, because of the time that has passed, are no longer with us themselves. And if they are still alive, they're older, certainly not affiliated with the companies involved. What is your opinion on going after people criminally for some of the things that, if investigated and if proven in a court of criminal law, innocent until proven guilty, but still, what is the chances that charges in a criminal sense would ever have been brought in or could be brought?
Oh, they'll never be brought. They could, but they'll never be brought. There's no political will in the DOJ to do criminal prosecutions or take these cases to trial. They're too complicated, they're too expensive. The government's dealing with other issues that are, that are more in the sort of normal wheelhouse of criminal conduct. It's truly a shame, because if there was criminal liability, or these people were held criminally accountable, these people who committed these conducts, you have somebody who made a decision to conceal a study, and that has led to the death of tens of thousands of people from cancer. That's a level of atrocity that should be criminally prosecuted, but it never is. If there was a politician or a will to do that, it would change everything. It would put me out of business, which candidly I welcome, right? Because what would happen is these companies, these executives, realizing that they're criminally on the hook for their actions, they won't do it anymore. And when they're in that boardroom deciding, do we bury this study? Do we hide this science? Someone's going to say, I won't be part of this. I'm not going to jail. And if that kind of accountability was really created, which is lacking in our corporate run political system, so I don't think it's going to happen. But if it did exist, it would change everything. Our regulators would actually do their jobs. Corporations would have the fear of criminal prosecution, making them do right. But, that's not where we are right now. We are right now in a legal precedent where people in power are criminally immune. We are in a world where the wealthy are allowed to get away. And unfortunately, that means the failure of our regulatory system, the failure of our justice system falls in the backs of us, ambulance chasing plaintiffs' lawyers who have the courage and wherewithal to take these people on and actually get some justice. So the fight is happening in the civil form, but I welcome it happening in a criminal form. And I welcome it putting me out of business, because candidly, it should be a criminal prosecution. So
I have a personal question for you, and this is something you've had to have thought about. If a doctor prescribes a medication for you, you come out of your doctor's office and you have a prescription. What do you do? What goes through your mind before you decide to fill that prescription and take that drug?
Quite a bit. I do a full PubMed research. I look at the epi, the clinical trials that exist. I explore the various known side effects. I make sure that if there's any ongoing litigation, I find out about that immediately. I'd say 90% of the time I do not take the prescribed medication, or not. That's not true. I talk to my doctor and I say, listen, here's my concerns. I don't feel comfortable with this. And they say, that's fine. Let's figure out some other medicinal way, like, vitamins or exercise or something to deal with the issue. But I do take prescription medications, and I have, and I'm very careful about the ones that I take. I make sure I get them on brand. For example, I don't buy generic medications because I don't know if people know this, but if you take a generic medication and you get hurt, you have no one you can sue. That's something the Supreme Court did a long time ago. Blows my mind that no one really knows about that, but it's a fact. So stick to brand, even if it costs a little bit more. And I'm very careful about the medications that I take, and not just for myself, but people in my family. When I find out that my mother is taking some medication, I sit down and I do all the research. I do not trust the label. I do not trust the FDA. So I have to do the work myself. And you'd be surprised that there's literature out there. It requires a scientific mind. It requires some diligence. It requires a lot of work. And I wish I didn't have to do it, but I would advise anybody who's going to take a medication to be careful because, candidly, even drugs that have been on the market for a long time, like Zantac, they can be built on a house of lies. And sometimes you have to do your own work to see if you can unpack those lies. Sometimes you can't. You just can't know. But if you can, you should.
Well, that's my final question. A person that might not have your experience and your ability to read scientific papers and to find that information, what's your simple advice for someone who's got a prescription in front of them or has a medicine cabinet full of prescription medications? What should they be thinking? What can they do to basically take care of themselves in ways maybe that the system may not look after them for?
It's a hard question to answer. I'm not a medical doctor, and I don't want to give medical advice. I also, am in a situation where it's so unique to an individual. But I will say that as a rule of thumb, try your best to get informed. Don't just trust the system. Yes, you should trust your doctor, but you should challenge your doctor. You should ask questions. What are the side effects of this medication? What are the things that maybe you don't think are likely going to happen? What do I really need to be paying attention to? Because so many side effects on a medication can be fixed if you identify it early, right? For antidepressants, they can actually induce suicidality. But if you know that you're suddenly feeling suicidal while you're taking an antidepressant, this is a drug side effect, and you can go reach out to your doctor and get it fixed. Or, if you're taking medication like, all these people taking Ozempic, right? You can have a seized gut that could be very damaging and life-threatening. So you should be aware of that side effect. And if you have the symptoms of it, go to your doctor and make sure it doesn't get out of line, because a lot of these things can be fixed early. So I think the answer is ask questions. Don't be afraid to insist on knowing what you need to know and asking the doctor to say, what do I know? Read the label to the extent you can. Those things are dense, but read them and ask questions of your doctor. I know sometimes doctors don't have time for us, but they will make time. And my experience has been that when you ask a question, the doctor will answer it because they do ultimately care about your health. So ask questions. That's probably my advice on all aspects in life, whether it be politics, religion, or even, the medications you take. Ask questions.
Brent Wisner, thank you for joining us today.
Thank you so much, Tim. I really appreciate being here.
To learn more about all that we talked about here, please see our episode page at shapingopinion.com. Make sure to leave a rating and review and subscribe wherever you get your podcast. Want to connect? Check out our website, shapingopinion.com. Follow us on the X platform, Facebook, or Instagram at Shaping Opinion. And make sure to join our Facebook group called Shaping Opinion Podcast Listeners. Shaping Opinion is a production of O'Brien Communications. Copyright O'Brien Communications 2024.